Today, we're going to talk about new legislation that could put your company at risk if you aren't prepared. In today's environment, companies are experiencing a lot of internal changes. And externally, the Biden administration is advancing the ball on protecting employees, especially related to hot topics like sexual harassment, non-disclosure agreements, pregnancy, and women returning to work after the birth or adoption of a child. And there could be severe consequences if your HR team doesn't follow the letter of the law. Today, we're talking to legal expert and practicing employee advocate attorney Joyce Collier, partner at Uebler Law. Joyce has over 30 years of experience handling employment cases in state and federal court in Pennsylvania and New Jersey, cases that involve discrimination based upon age, gender, pregnancy, national origin, disability, and race. She has also advocated for victims of sexual harassment, retaliation, and wage theft. And she has also represented employers in helping them avoid litigation by helping them write policies and handbooks, as well as conducting audits and compliance seminars. Collier graduated with high honors from Rutgers School of Law, receiving the Most Promising Civil Litigator Award. She clerked for the Honorable Justice Robert Clifford in the New Jersey Supreme Court and has been named a Pennsylvania super lawyer for 10 years running. She has also served as an adjunct law professor at Rutgers School of Law Camden in the area of disability law. Joyce, welcome to Voices of HR.
Thank you, Berta. It's great to be here.
Well, we are so excited to have you here, and what a resume. And I think we actually cut that down as well. But we are so excited to have you here and lend your expertise to our Voices of HR audience. So this administration has passed some key legislation protecting employees that could really put employers at risk if they aren't prepared. And although you're an employee advocate, you've also helped employers prepare and minimize the risk. So we're so excited for your perspective, because if companies do not adhere to these new laws, they're putting themselves, their brand, their ability to hire and retain top talent really at risk. So if we can, let's start here. So today we're going to share with our Voices of HR audience some of the most impactful legislation that has been passed, let's say in the last 1 to 2 years. So for our listeners, would you be open to explaining what the new law is, how our HR pros could adapt internally to these new laws in order to protect their company and its employees, and what are the risks if they do not? So let's start with the most recent laws and work our way backwards in time. So the first is the Pregnant Workers Fairness Act that will become effective on June 27th, 2023. This is substantial legislation and has a lot of bite you're anticipating in the court system. What is it? How should HR pros adapt? And what are the risks if they do not?
Thank you, Berta. I'd be happy to share this information. And I really believe that it's that whole thing about an ounce of prevention. I think that the more HR and employers can become aware of the new legislation, incorporated into their handbooks and policies, which is what I'm actively doing for employers, the better off they are, because it's just a matter of making sure that you're following the policies that you've put in place. So let's just talk about the Pregnant Workers Fairness Act. This applies to public and private employers with 15 or more employees. So it's a large gamut of employers. And it requires covered employers to provide reasonable accommodations to a worker's known limitations that are related to pregnancy, childbirth, or related medical conditions, unless that accommodation would cause the employer an undue hardship. So those words may sound familiar because the undue hardship standard is the same standard that's in the Americans with Disabilities Act. So what the Pregnant Workers Fairness Act is doing is really saying that whenever a pregnant worker is experiencing a hardship or a difficulty relating to their pregnancy, an employer can't just say, well, you've got to go and take some paid time off, or we can't deal with that, right now. It really is a matter of doing the same thing that employers are required to do under the Americans with Disabilities Act, engaging in the interactive process. And what that means, obviously, is that there needs to be a back and forth communication about what accommodation is necessary for the employee. So, and also the Pregnant Workers Fairness Act doesn't require the employee to show that similarly situated persons are receiving the same accommodations. So, how are these things important? Well, they're important because an employer really should change its policies and procedures by incorporating the Pregnant Workers Fairness Act accommodations policy into their handbook, the same way that they have a policy on the Americans with Disabilities Act, a reasonable accommodation policy. And what do I mean by that? I mean that the handbook should have an actual form that an employee can submit to HR that says, I will need to have this reasonable accommodation, provide a doctor's note or certification that this accommodation is necessary if the employer requires it. So it's not like the FMLA where doctor certifications are required, but it's okay for the employer to say, look, we need to understand what this accommodation is and why you need it. So the other thing that's also really important is that the Pregnant Workers Fairness Act does protect employees from retaliation, coercion, intimidation, threats, or interference. So in other words, there can also be claims for retaliation, even if the accommodation seems as an undue hardship for the employer. The employer can't then say, well, this employee was causing us so much trouble by asking for all of these things, and then take action against the employee. The EEOC is going to be issuing regulations on the Pregnant Workers Fairness Act within the next year. So it's very important to keep an eye out for those regulations to make sure that as an employer, you understand how they interact with your handbooks and your staff.
So as a quick follow-up to that, I'm an individual, I'm a one-person HR shop in a company with more than 15 employees. Am I obligated to communicate out to all the employees about these new laws? Or am I just accommodating and satisfying the law by simply putting it into my employee handbook?
That's a great question. So I think it's very important for the employer to make sure that they're updating their posters. I think it's also important that to communicate, look, we're updating our handbook to take into consideration these new laws. And certainly if you want to include within that the EEOC's guidance or a fact sheet on it, you certainly can do that. And we're posting at the end of this podcast on the link, you'll see some of the EEOC and the Department of Labor's guidance on particular laws. So the EEOC is in charge of the Pregnant Workers Fairness Act. The next law we're going to talk about, the PUMP Act, is actually the Department of Labor. So it's a separate federal agency. So it's kind of important to make sure.
Yeah, that's a great delineation. I don't think I even knew that. So that's why we're so glad that you're here. So let's move on to the PUMP Act. So it's really along the same vein as the Pregnant Workers Fairness Act in that it protects pregnant workers. But how should the HR pros prepare and also give us some guidance, because it comes from the DOL, as you just said, not the EEOC?
So let's talk about the PUMP Act. For over a decade, federal law has required most employers to provide nursing mothers with a reasonable break time to express breast milk after the birth of their child for up to 1 year. That was called the Break Time for Nursing Mothers Act, and that was passed in 2010 as part of the Affordable Care Act. But the Pump Act actually provides additional workplace protections for employees who need to express the breast milk and also protecting an estimated 9 million more employees. The Wage and Hour Division last week published enforcement guidance for their workers to go out and make sure that employers are complying with the law. What the Pump Act does is, again, reinforce the right of nursing mothers to break time and a private room to express breast milk for their nursing child. And it also includes teleworkers. So how does this act apply, or what does it do? It says that time spent pumping must be counted as hours worked for the purposes of minimum wage and overtime requirements. Now, there isn't a set standard for how much time must be given or spent. There is the law is nuanced in the sense of saying that frequency, duration, and timing of breaks will vary depending on factors related to the nursing employee and the child. Employees and employers may try to create a fixed schedule, but pumping needs may require adjustments and exceptions. The Pump Act also does something new, which is that it allows an employee to file a lawsuit if the employer has violated the break time requirement or has indicated it has no intention of providing a private place to pump, or if an employee has been fired for requesting break time or space to pump. If an employer has not provided an adequate space to pump, the employees must notify their employer, and the employer has 10 days to comply. So there is a notice provision in the Pump Act.
Okay, so for employers, definitely this has come down the pike. They must comply, and we are protecting workers more broadly who want to express, who want to pump, who want to provide this vital source, obviously, to their infants. So kudos to our administration for protecting women. So the third piece of interesting legislation that was signed, so now let's go to last year, December 9th, 2022. President Biden also signed what was called the Speak Out Act, limiting the enforceability of nondisclosure and non-disparagement clauses in sexual harassment cases. So what is that? And how should HR pros adapt, and what happens if they don't?
So what the Speak Out Act does is it prohibits non-disclosure agreements that are part of a employment agreement or confidentiality agreement that's in your onboarding forms. So it's only the types of agreements that are entered into before a dispute arises. It does not prohibit NDAs that are contained in settlements of cases. So, those of us that are more employee advocates are disappointed to the extent that it doesn't have more teeth to prevent NDAs in general in sexual harassment cases. Now, state laws, there's many state legislatures who are enacting laws that prohibit NDAs in settlement agreements of sexual harassment cases. So the state of Washington, Oregon, New Jersey, Illinois, Nevada, New Mexico, and California, for example, are states that already on their books have laws that say, and in different ways, that settlement agreements that contain NDAs are prohibited unless the employee wants the information to be held confidential. So I think that the onboarding forms are the things that employers really have to go back and double check and make sure that they are in compliance with the Speak Out Act. We're going to talk about onboarding forms later as well when we move into some other areas, including the arbitration provisions.
This sounds like a big one. Back to your main point at the beginning about an ounce of prevention. Sexual harassment, more of this better than I, but it's still so prevalent in today's workplaces. And which just amazes me. It's 2023 and we still have this occurring. And so anything that the employer can do to, number one, adjust their process on the front end, but also I would suspect train and make sure that everyone knows what sexual harassment is and that employers should never tolerate that because it does put them at risk, especially now. I mean, you don't want a whole bunch of your women, in that situation, but also they're going to be able to tell people about it now.
Yeah, I think that any kind of sexual harassment training is critical and it should be done every year. And particularly in, believe it or not, in male dominated industries where there may be one or two female workers on the site. Many times employers in those situations don't want to do that kind of training because it's, more of a guy's environment. And they're afraid of what the impact of that is going to be on the men that work there, that they might just think it's funny or stupid. The reality is that that's probably the most important place for a lot of these seminars to be provided.
Mm-hmm. It is. And, I do always look back and think, okay, so many of these industries were very male dominated for a very long time. And I have brothers, I have a husband, I have a son. And, sometimes they don't realize that they're crossing the line. Some do, but let's give them the benefit of the doubt. So as an employer, you actually should support your men in your organization by giving them this training. Now, whether they think it's stupid or not, that's up to them. But, anything that you can do to better educate, because times have changed. It's not the same as it was 20, 30 years ago.
And we would really hope that when a male manager hears another man say something inappropriate, as an aside, that they'll say, that's totally inappropriate. And it is a violation of our policy. It shouldn't be up to the women to be the ones to bring it to HR's attention. There are some people who will use inappropriate language, and it just has to be called out when it happens.
Absolutely. Absolutely. That's the best remedy right there. So let's move on to the fourth law, which was signed back in March of 2022 when President Biden signed into law the bill that ends forced arbitration in workplace sexual harassment and assault cases. So now we're starting to see a theme here of protecting women in the workplace, especially from the horror of sexual harassment, which even in 2023 is still so prevalent in the workplace today. So can you tell us a little bit more about the law that was signed and what employers need to do to comply? And maybe in this case too, an ounce of prevention would actually really, really help them, because I do think that the laws are changing at such a rapid pace that and males typically are the perpetrators of this in the workplace. I think on a 9 tenths of or 9 out of 10 cases, it's a male that is a perpetrator in the workplace. Would you also recommend the ounce of prevention that you talked about at the beginning with training? And how can training actually help employers maybe comply, but also stay out of court?
Right. So, the important piece about this law is that pre-dispute arbitration agreements and joint action waivers, that's like a class action waiver, on sexual harassment claims and sexual assault claims are unenforceable. So that applies to all employers. In other words, all employers are prohibited on an onboarding form or an onboarding at the time that they hire an employee to say, you agree that all of your discrimination claims, including sexual assault and sexual harassment, are going to be arbitrated. No longer can employers require that. They can require arbitration of non-sexual assault and non-sexual harassment claims in certain states. So what's really important is to make sure that you check your state law. So, for example, New York State originally said, also before this law was put into effect, that you couldn't require employees to arbitrate sexual harassment claims. But now their law has expanded to all claims of discrimination. Illinois, Washington, and New Jersey also have laws on their books concerning uh, arbitration agreements and their enforceability with regard to employees. California has prohibited all employers from mandating arbitration agreements as a condition of employment. And this was before the Biden law. So you've got to be aware not just of the federal laws, but the state laws, and sometimes even the county laws. For example, here in Philadelphia, we have county ordinances. And so, as well as the New York City has one that have even more expansive protections, for example, for family status, or even more for an LGBTQ issue. Those are local laws that have greater protections for employees.
So there's layers of laws here. You have your federal law, which was signed by President Biden. You now have some states who have stepped up and expanded or deepened that law, offering more protections. And then you're saying, even look at your county, because your county could offer even deeper protections.
And usually that's just in your larger cities. I mean, you're not going to find that in more rural areas, but it's definitely worth checking out and making sure that you understand what's going on in your state. Another example is New Jersey has an amazing law, state law, on discrimination that actually provides very, very good protections to employees and doesn't require that they go to the EEOC to file a formal administrative charge first. They can just go straight into court. Other states also have very protective laws for employees on their books. California is an example.
Yeah, California and New York always seem to be leading the way when it comes to protections of employees.
And New Jersey. I would say New Jersey is equally up there with a lot of great wage theft laws and equal pay laws.
Mm. Okay, so now we have covered all of the laws that are either on the books or coming, June 27th, I think we said. So now if we can turn our attention to upcoming legislation and potential new laws, so our HR pros can proactively start thinking and prioritizing these accommodations. So what should our HR pros keep their ears to the ground on regarding new legislation that is coming up this year? Or is there any legislation related to women in the workplace that's being discussed that you expect to move to the forefront? And I know one of those pieces actually just came out last week when the EEOC provided some guidance on the use of AI, which has been such a hot topic in the media, social media, all over. So let's start there. Can you give us an update on the EEOC's guidance on AI?
Sure. So with regard to AI, and this is no surprise, imagine that if an employer administers a selection procedure, it is going to have to be responsible for making sure that the procedure, the algorithm, doesn't violate Title VII or the ADA or any other law by making sure that it somehow makes it difficult for an employee of a protected category to get hired. And there's actually a particular standard that can be looked to. It's called the 4/5 rule. And I won't get into a detailed explanation, but it's the whole notion of making sure that these algorithms don't screen out people of color or people of a national origin or people that have any type of protection with disabilities. The EEOC had already issued a guidance on the use of AI to screen out people with disabilities. So this more recent enforcement guidance sort of mirrors that and also says if you turn this over to a vendor and the vendor doesn't comply, you're still going to be responsible. You can't just say, well, I didn't know whether this vendor was following Title VII. That wasn't my job, that was theirs. You can't absolve yourself of that kind of responsibility.
Mm-hmm. That's interesting because, in today's environment where there has been a talent shortage in some industries, and there's a lot of movement now occurring, with talent changing companies, and, it's expected to continue here in the next 12 to 18 months. Of course, a lot of organizations have turned to efficiency to scan resumes. And so what you're saying is, even if you've turned to a vendor to do this, using AI tools and certain algorithms, you need to comply with all of the existing laws.
Right. I mean, you can only imagine there's, it's kind of unlimited, but let's say the screening tool looks at who attended a historically Black university. I mean, and somehow, or there's some other basis on which, whether it's where the person lives, ways in which the algorithm may take into consideration a race or color or sex or national origin, um, and kind of screen out or lower the opportunities for persons of protected category to get positions within the company. And this all goes to the issue of what's called disparate impact. So there's disparate treatment, which is direct treatment against an employee regarding discrimination, and then disparate impact is a much more statistical showing of how a particular category of people are treated with regard to job opportunities. I'm particularly interested in how it affects the aging population. I mean, imagine how difficult it is for a person over 60 to really understand and operate within the nuances of new technology, to apply for jobs that way. Or they may not have access to computers to do all this, the application process. So employers really, and they really need to make these opportunities available to people of all different backgrounds. You also asked about sort of what else is out there, and I think one of the things that we heard about at the beginning of the year was the FTC's proposed ban on non-compete agreements. That was a proposed rule that may never become final. The comments were due to the FTC in March, but the FTC extended the comment period, and we believe that the FTC is now inundated with comments on that. But other things that are out there, which I think are very important to take into consideration, include the Supreme Court's upcoming decision in a case called Groff versus DeJoy. That relates to religious accommodations. So in the past, an employer had a different standard for accommodating a religious a request for a religious accommodation, a different standard than the standard in the ADA. So the ADA says it has to be that if it's an undue burden, the employer is not required. But that's a very, very high standard. In there's a line of case law for religious accommodations that allowed a much lower standard to be met. And it may be that the Supreme Court raises or increases the standard, making it harder for employers to deny religious accommodations to employees. So we're going to find that out in the next probably month or two. That's sort of some of the developments. I think the most important thing is to keep your ear to the ground in terms of what the EEOC is doing, what the Department of Labor is doing, and to a more limited extent, what the National Labor Relations Board is doing. When I say to a limited extent, I mean if you're not a non-union employer.
Right. Now, you had also mentioned when we were speaking before about, we have a lot of employees who decided during the pandemic to move to a different state or, relocate because they thought that their employer was going to allow them to work, that way forever. And some employers are now saying, come back to the office, or you have to be in the office 2 days a week. So when we think about these hybrid environments, is there one or two things that you would recommend employers remember or take into account while they're making these decisions? Because I think a lot of this is so still in play.
This is going to be in play for a long, long time. And I have gotten calls from people that have said, look, they let me move to another state. And now they're telling me that I have to move back and come to this work site. And in that situation, it's more of an issue of promissory estoppel. Did they make a promise that you could stay in that particular state? And I think it's also very important for the employer to make clear what their expectations are for telework. I think this is going to be one of the new hot issues. That is, what does the job offer say in terms of where you're required to live, and under what conditions can the employer require you to come back to or move to, say, their central office? These things should really be discussed at the outset of any employment situation, particularly when it's a remote job opportunity.
And so what if the individual was in New York and they decided that Florida was their state, right? Sunny, it's warm, pandemic, it was cold. Which state, we talked a lot about how states have different laws when it comes to even some of this new legislation that we just talked about. Which state prevails?
Well, we're finding more and more in the case law that it's going to be the state that the employee is working from. So
working from, not
correct.
where the employer is.
Not where the employer is. So the employer may be under the impression that, look, New York law is going to apply, or Texas law, when the reality is that once the employee is now located in another state, that state law most likely will be the law that's applied to their situation. Now, have I sometimes leaned to the employer's state when the law is better? Yes. So, I think that there's a whole divergence of issues on that. And then once the case is filed, there's also questions about where the venue of the case is going to be. So imagine a remote employee, let's say in Texas again, files a lawsuit. Does that lawsuit have to be in Texas, or does it have to be in the area where the employer's main headquarters are located? So that's going to be another issue that's going to go back and forth for employees who are working remotely.
Mm-hmm. So again, another data point to take into account, employers, HR pros, as you're considering what this hybrid environment potentially looks like for your company moving forward. During the pandemic, Joyce, we also had employees that were affected from a mental health perspective. And we are continuing to see this emerge as something that employers are acknowledging and really trying to help remedy for their own employees. How can companies protect themselves, and how can they help protect their employees?
Yes. So one of the big pieces on the mental health and in general physical health issues that I see a lot, and it's been around since the beginning of the ADA, which is now over 30 years old, is around the issue of confidentiality of medical information. So the Americans with Disabilities requires that medical information be maintained in a separate file away from the personnel file, and that it's only discussed between managers on a need-to-know basis. I find that very often employers have disregarded that, and particularly when it's a small HR department, right? They're not going to know that they have to separate that information out, or they might not even be able to do it given the circumstances of it just being one person. The problem with that is that it's an easy target for a plaintiff's employment lawyer to say, oh, you mangled this information in there. People discussed it at a meeting. Somebody's eyes rolled when the issue came up. Medical information should really only be discussed with the HR manager, who should really caution be careful about what they want to disclose to the individual manager, because then the manager can say, look, I didn't know what exactly was going on. I knew that this person needed some additional time or needed this particular accommodation. And that's where I really think that having a written accommodation policy in your handbook is such a great idea, because then the employer can say to an employee, look, we have this policy. If you need an accommodation, please put it in writing, give it to Mary Jo at HR, and she'll work with you on that. So it's out of the manager's hands and into the hands of somebody who's much more familiar with the law and the way that that it operates.
I love that advice, because I think if you really don't know what to do or how to handle this, HR, keeping it confidential within HR is always the best practice. And it protects the employee and it protects the company.
And I think the other issue is boundaries, right? And we often really want to help people out and say, oh, gee, somebody comes into your office and they start to cry and start to tell you something awful about their life. It's very difficult to say, I'm sorry, I can't talk to you about that. But I think that it's very important for managers to be sensitive to, look, I know that things are not going well, and I do appreciate that you're sharing this with me. However, I think it's really important, if you need a reasonable accommodation, for you to go to HR and address that issue. I mean, why managers take on more than they need to out of compassion, right? It is often out of compassion and concern, but it can get them into trouble.
Mm-hmm. Yeah, and managers, they have a job already to lead their people, lead the business, get business results, right? You can't have a business if you don't have revenue and profits and all of that. And sometimes we forget that. But at the end of the day, let HR handle the complexity of what we're dealing with today, because they are the ones who know what to do and to keep your company, minimize your risk. One of the other topics that I'm really passionate about, as you know, is using the power of HR to protect employees. And a healthy workplace bill has been introduced. I think it's 39 states that protects all employees. They don't have to be just a protected class. It's all employees, men, women, different ethnicities, backgrounds, from bullying and abuse, which is so prevalent in our workplace today. And based upon my research and, some of the stories that I told in the book, this is so desperately needed within our workplaces. Even today, 40% of workers who are working remotely have said that they've been bullied in the workplace. So what are your thoughts on, is there any other legislation? Do you see this gaining momentum? Do you have any insight at all into any bills that maybe look like this, or this particular bill?
Well, I think this is a great bill. And I think that the reason for it is that, it's one of those examples of, please make sure that you train your managers and your people that are running the company about what is an appropriate way to treat another human being. What's an appropriate way to communicate? What's an appropriate way to hold still and not lose it on a worker? So I fully support this. I often get calls from people and they'll say, my boss is such a jerk. He or she does X, Y, and Z. And unfortunately, I'll say, well, is it just to you? Oh, no, it's everybody. And so in the employment world, there's sort of well, you can be a jerk to everybody, but just not protected classes. I will say that as an employment lawyer, whenever I see a bully in the workplace, I'm always ready to take a look, because I do think that there's a lot of unconscious bias that's out there. And, far more often, there are particular categories of people that are selected out to be the target of bullying.
Mm-hmm. Yeah. And bullies, the thing about bullies is that the more that they get away with, the more they became emboldened in the workplace, and they start crossing other lines. And, It could be ethical. It could be sexual harassment. So again, it's kind of like the snowball going down the hill, and it just keeps getting bigger and bigger. And so the best thing that HR can do is stop it from the very beginning and make sure that your policies and procedures allow you to do that. So it really feels like the tide is turning really from, I think, what some have described as, really corporate dominance in the past to employee advocacy, and more so than any other time in our history. So we so appreciate your insight and your expertise that you've shared today.
Well, I have to say, Bert, I've been listening to the other podcasts on this, the other people that you've spoken to, and I loved hearing about the millennials, for example, and their willingness to speak up. And I do think that this listening to this podcast in conjunction with what your other speakers have said is very important, because you are going to have different types of people in the workplace who are far more willing to say, look, I think this is wrong, or I want to know about, other wages that other employees are receiving. And this just goes back to state laws. For example, in New Jersey, there's now a Equal Pay Act that protects people of all categories. So it's not just gender. So if an employee says, I want to know about pay issues or how much other people are getting paid, arguably that employee may be protected from retaliation by requesting that information. So again, I think if we take a look at this whole HR spectrum in general, there are a lot of solutions other than what I'm saying, the handbook. That's really about the legal part. But from a 30,000-foot view, how can you have a great workplace that respects people? It's not just about being afraid of a lawsuit. It's about how to really provide dignity and respect to people in the workplace and see them as human beings as opposed to products or commodities.
So they don't have to come see you.
Yeah, I mean, it's so tragic to me. And I get the calls always on Friday afternoons, and somebody's crying that, they've been fired. And there are so many situations that can be prevented with, better insight, better HR support, I think. And I do believe in the power of HR to at least be there for an employee and help them through certain situations.
Mm-hmm. Absolutely. But I think at the end of the day, their job is to also protect the organization. So they have a balancing act.
And sometimes a conflict of interest. Yeah.
And sometimes, yes, absolutely. Okay, so we are nearing the end of our time together, unfortunately. And at the end, we play this game called Rapid Fire Questions. They are one-sentence questions that we ask our guests so that our listeners can get to know you just a little bit more. Are you willing to play?
I am.
All right, let's do this. What is a book you have read and given away most often, and why?
So it's called Difficult Conversations, and it's a book that my law partner, Julie Uebler, gives out. It's a wonderful book about why it's so hard to have the most important conversations in the workplace and how to have them.
Fabulous book. Fabulous book. What has been your greatest success as a practicing attorney?
So years ago, I had the opportunity to work with Gloria Allred and Nathan Goldberg, and on a couple different things. But one was the women who were the female cocktail servers who were fired because they were older and they couldn't fit into a skimpy uniform at a New Jersey casino, and they were really the most lovely people I had ever worked with, and I so enjoyed that experience and the opportunity to work with Gloria and Nathan.
She's a powerhouse. What advice would you give to a young professional just starting their career, whether it's in the legal profession or not?
Hang in there. Always look for opportunities to grow and change. I still attend a ton of seminars and all sorts of different things to learn and grow. It is never too late to learn. And it's fun. I mean, you can be in the law profession, you could reinvent yourself every day.
Absolutely. What keeps you up at night?
I would, to be honest, I'd say personal family situations. And I think that that's, again, tying into employment. I really believe that the FMLA is a wonderful tool, allowing employees an opportunity to take care of a sick parent or a sick child. Those situations can really interfere with our ability to work. So allowing an employee the space and time to take care of their personal situation is critical.
Why should the C-suite at any given company give HR the credit they so deserve?
Okay, well, here's where I give the lawyer draconian answer, which is that they're going to be testifying on the witness stand. They're going to be the first witness that a plaintiff's lawyer is going to call, probably in their case in chief, to say, what are your policies and procedures? And then they're going to compare what the employer has with what SHRM has as their best practices, or they're going to question the HR manager on what efforts they undertook to investigate something. They're going to ask them, what's your proportion of HR to staff ratio? And SHRM has one that's, I think, 1 to 100. But, those are all the things that an HR person is going to be asked about. And if the HR person isn't good at their job or supported by their employer, it's going to be so evident.
I always say that even though the HR professional is paid and works for a company, they also work and are paid, not paid. They also work for federal and state and county laws. They have to adhere. It's their job.
Yeah, that's really true. And I think that should help HR people to say, look, this is what I'm trying to do. I'm trying to make sure that we're in compliance. And we often represent HR people when they come to us and say, look, I tried, and they wouldn't follow the law. And then there's a whistleblower case. So, again, I don't mean to be the heavy here on this, but these are real legal reasons to support your HR people.
Joyce, what is the main takeaway you want to leave our listeners with today?
So there's two things. One is that I think that employers really have to support their HR staff in becoming members of SHRM, having access to the SHRM website. I always have a membership because I think that there's so many amazing resources on their website to use, whether it's policies or procedures or legal issues. So I think SHRM is key. And also to make sure that you purchase employee practices liability insurance coverage. So that's called EPLI coverage. EPLI coverage is additional coverage for any claims that are made based on violations of employment law. And while many times an employer will have a large deductible, or there'll be a deductible on that policy, at least if there's employment claims, those claims can be assessed, and of course, because the duty to defend is broader than the duty to indemnify, you're going to have an insurance appointed counsel at some point in time to step in and take over the litigation, even if there might not be such grounds for indemnity. So again, I would really make sure that you have EPLI coverage.
Well, today we have been joined by Joyce Collier, award-winning employment law attorney with Uebler Law Firm. Joyce, thank you so much for joining us on Voices of HR. It's been such a pleasure.
Thank you. It was a lot of fun.
I really hope you enjoyed this episode. Thanks so much for watching. We would love it if you shared your thoughts on any of the topics we discussed in the comments below. And if you got value from the video, it would mean the world to us if you hit the like button and subscribe to the HRMorning channel. Thank you so much for joining us, and we'll see you next time on Voices of HR.